We're talking about 9 unelected officials that most people couldn't name or wouldn't recognize if you were sitting next to them in a restaurant. They are making decisions about some of the most kind of contentious social and morality issues, things like physician-assisted dying or abortion or so on and so on.
Now, this is no longer about the topic of judicial review. I think you're talking about who gets the last word in people's life. Is it going to be the people that they elected or the people in robes?
Once a country like Canada, once they get a constitutionally codified Bill of Rights, we call ours a charter, there's been this sort of escalation towards the courts having more and more of a role and a final say over the most divisive issues of public policy. The elected officials have been, in many cases, kind of complicit in facilitating this process. Our elected officials, a number of them, have been really keen to kind of outsource or subcontract out these divisive issues to the courts.
Would you say that we're seeing a quiet transfer of power from ballot boxes to the bench? Political science professor and constitutional scholar Mark Harding has spent years documenting a quiet power shift, one that most Canadians have no idea is happening. This is the episode you didn't know you needed. Let's start with, what do you do for work?
Yeah, so I am an assistant professor in the Department of Political Science at the University of Guelph. And so, as a professor, most of my job, or the part that's kind of the most prominent that people see, is I teach courses and I do research and write things. And some of those writings get turned into things for public consumption, op-eds and journalistic articles. And then a lot of the things that I write about are related to the law. And so I write often in law review articles, and sometimes those are taken up and used in court cases and are cited by the Supreme Court of Canada and that kind of thing. But yeah, I'm a political science professor, and my training has been as a political scientist. But the things that I write about in research tend to relate to law and the relationship to politics.
Right. So what's your research about generally?
So my research focuses on constitutional issues and specifically how courts interpret rights issues. And so in the Canadian context, which tends to be my focus, how judges make decisions, how they interpret the Constitution, and then the implications, kind of the effects that those interpretations have on law and on policy, and what that means for the relationship between courts and legislatures. So most of my research tends to be fairly theoretical and descriptive, although I do some work that is empirical and quantitative as well.
Well, you wrote about judicializing everything. I read your article as well, which is it's actually a popular article. I saw a lot of other works that cited that article. Traditionally, people think like this. They think that the courts are weak, especially when you think about it in the context of a parliamentary system, like in Canada and the UK and New Zealand, which you cited in your work as well. In that courts are strong when you consider that in the context of the United States, especially. But going by your article and your book, I wonder, would you say that's a false dichotomy?
Yeah, so usually the way that we think about the relationship between courts and parliaments, if we're talking about the English-speaking countries that you mentioned, leaving maybe aside the United States for a minute. So usually the way that we think about particularly issues of rights protection and how our rights are protected by political institutions, they're sort of often thought to be sort of two traditions: the American tradition, which is contrasted to the British tradition, and then the British tradition, which Canada is an inheritor of. It's the parliament that is the ultimate lawmaking body. Anything that the parliament does can be undone by a future parliament. And this is connected to this idea that's sometimes called parliamentary sovereignty or parliamentary supremacy. And then in contrast, sort of at the other end of the continuum, is the U.S. approach, which is called judicial supremacy, which is the idea that you have a final court of appeal, the U.S. Supreme Court, that it can strike down, it can invalidate laws that the Congress or the state legislatures have passed. And so typically amongst the English-speaking countries, we kind of think of there being this kind of continuum of the British approach versus the American approach. But then that distinction starts to break down a little bit in practice, and you can start to kind of put different states, different countries along that continuum. So Canada has always actually kind of straddled or been kind of in between a pure British system and a more American system. So Canada's had a written constitution since 1867, and the constitution spells out, the powers and the responsibilities of the federal government and the provincial governments. But very early on in Canada's political development, there were disputes about how the different provisions of the constitution meant, what they meant in practice, and there were a lot of conflicts between the federal government and the provinces over what the powers of the constitution meant. And so courts played a role in our system, but rather than striking down laws and saying no government can legislate in this area, typically what would happen is sort of one of the two levels of government would have that power. And then that started to change when Canada got the charter in 1982. And then Canada started in 1982, and in the decades that have passed since, Canada's system now looks a lot more like the U.S. system in a lot of ways. And so going back to your comment about kind of, we think of courts as being kind of weak. And on paper, courts, in some ways, they are weak because they can't enforce their decisions themselves. Like, they've always relied on persuading the rest of the political system or the other branches of government to act upon their decisions. And what I've written about in that book that you referenced, and other scholars that work in this area have noticed, is that there has been this sort of ratcheting effect of, once a country like Canada or the other English-speaking countries, once they get a constitutionally codified Bill of Rights, we call ours a charter, and different countries have different nicknames for the same mechanism, there's been this sort of escalation towards the courts having more and more of a role and a final say over the most divisive issues of public policy. So the book is the book that I wrote called Judicializing Everything, that came out in 2022. It's an extension of my PhD dissertation, and it tries to kind of describe and document how that process that I just described, how that's kind of played out in Canada, New Zealand, and the UK.
Right. Before we go further into taking some of these thoughts that you started with, we'll try to really get deeper into them in a second here. But I'm thinking about something. If an average person on the street watches this conversation away from the lecture hall, why do you think they should care about the role, the interplay of the court versus political office or elected office holders?
Yeah, no, that's a great question, and probably one that I and other professors should think about more often, is sort of, why does this matter? And the short answer is that as the role of the court expands, which it has in Canada and it has in these other countries that I reference, is that when the influence of one institution expands, it comes at the expense of something else. So in Canada's case, that means that the role of Parliament, the role of your elected officials, and by extension, like your vote, like your influence over how you're governed, that shrinks. So you can think of power as being like a finite thing. And if one institution's power is growing, that's coming from somewhere else. And so part of what is troubling or concerning is if the courts take up more and more of the decision-making power, then that means that has effects on how our democracy operates. So your elected official who's supposed to represent you, their job matters less, and they have less to do, less influence, and instead the people who are making these important decisions, these are, if we're talking about the Supreme Court of Canada specifically, which tends to be the focus of my work, we're talking about 9 unelected officials that most people couldn't name or wouldn't recognize if you were sitting next to them in a restaurant. And so I think that the person on the street should care for that reason.
Yeah, after I read your articles, I wrote down here, said that this is no longer about the topic of judicial review. I think you're talking about who gets the last word. People's life. Is it going to be the people that they elected or the people in robes? I think that might actually be another key reason why the average person should care about this conversation. And this is me just trying to make a pitch before we get into the rest of the conversation so that people find the value in it. You want to chime in?
Yeah, I would agree with that framing. And I guess the thing to think about is that the issues that the Supreme Court of Canada are weighing in on, these often aren't straightforward issues. They're often very hard questions, but they also aren't often highly technical issues that regular people can't understand. So, they are making decisions about some of the most kind of contentious, social and morality issues, things like physician-assisted dying or abortion or so on and so on. And these are not technical issues that you need a law degree to understand or to have an opinion on. But part of the reason why, when I talk about judicialization in my research and in that book, is that part of what's happened in Canada and these other democratic countries as well is that these issues that used to be dealt with by parliaments and by elected representatives, and then by extension, you as the voter could elect people that have different, philosophies and attitudes and morality or accounts of morality. It's more difficult that democratic input, to have as much of a sway over these important issues. And instead, the issues get sort of transformed into legal issues. And in our country, we say, well, if it's a legal issue, then lawyers and judges need to be the ones that decide them. And so it cuts out or dilutes the role that regular people or your elected representatives have in shaping those things. And so again, I think that's why people ought to care, even if you don't pay attention to the Supreme Court as much as I do.
Right. And just before we get into some of those topics you raised about the social issues that the courts are actually making decisions about here, I was thinking, hardly do Canadians even know how the judges are selected. In brief words, how does this work?
Yeah, so it's funny that you mentioned this because there is a lot of polling data that shows when you ask Canadians, like which institution should get the final say or which institution you trust more, courts or the Supreme Court or Parliament. And the courts tend to have way more deference from Canadians. Like Canadians are way more trusting of the Supreme Court over the Parliament of Canada. But then when you tell in the same surveys, when you tell people, like, do you know how Supreme Court judges are selected? And people will say no, or the number of people who know how they're selected is very, very small. And then you tell them, well, the prime minister picks them, which is an oversimplification, but is essentially true. Then the trust or the deference for the court goes down. And so lots of people are not very, informed about some of the complexities of the way our democratic system works. And I, as a political scientist, I teach this stuff and think about it all the time. And I don't even think that everyone needs to know everything about the Supreme Court of Canada. And I say to my students, you can kind of think of the role of the student in a political science class as like, they're sort of like the herd immunity for the rest of the democracy. Like there needs to be like a chunk of people, like maybe 30% of the population that needs to know some of these technical issues about how, like the details of our democratic system, to be able to tell other people, like, this is a big deal, or this is controversial that a government is doing this or not doing this. And so I don't expect everyone to know how the Supreme Court operates. But yeah, I mean, it's an institution that's not elected. It has 9 members. The distribution of the court is actually, there's a kind of custom that our court is, that the seats on it are allocated based on region in Canada. So 3 of the 9 judges are from the province of Ontario. 3 of the 9 are from the province of Quebec. 2 are from Western Canada and 1 is from the Maritimes. There is also kind of a kind of custom that there's gender parity on the court. So half the court are female justices and half of them are male. Again, that's not like a law or not written in the Constitution, but that's been something that prime ministers have kind of strived for. A Supreme Court judge in Canada can sit until they're 75 years of age. So we don't have term limits, but there's an age ceiling. Once you're 75, you're no longer allowed to sit on the court anymore. In the US, they have lifetime appointments, and often justices on the US Supreme Court will sit until they're very old and sometimes even die in office. Has happened from time to time. And so when there's a vacancy on the Supreme Court of Canada, there is a process that is run through the Justice Department, which is the federal government department that handles judicial issues. And there's actually an application process. Judges can put their names forward to be considered. And then there is a committee that helps the justice minister to go through those applications and to present a short list to the prime minister. And the prime minister makes the selection. And again, this is a very technical matter, but it's technically the governor general, which is the Queen's representative. It's actually their appointment, but the governor general only appoints someone that the prime minister would recommend. Kind of the way that I've explained this to most people is that the prime minister picks, but there's all these sort of like technicalities and formalisms that go into it. But no one would ever wind up on the Supreme Court that the prime minister didn't really want to see on there.
So the prime minister picks them the same way the prime minister picks the Senate members here in Canada, for instance?
Yes. So that's right. So, and with the Senate too, is there's also a committee that makes recommendations. But again, the prime minister is not bound legally to pick anyone even from that process. They technically could pick someone outside of that process. Prime ministers tend not to do that kind of thing. But yeah, so again, this kind of gets us back to some of the politics of this stuff, is that prime ministers will want to pick individuals that share their vision for how the Constitution ought to be interpreted, how the country ought to operate, what the relationship between the federal government and the provinces ought to be. And so there's lots of both kind of identity considerations that go into these appointments, and then also kind of philosophical or political ones. So again, to oversimplify, liberal prime ministers would tend to pick judges that will be more kind of progressive or more activist in terms of how they interpret the charter. And then conservative prime ministers, would pick judges that are going to be more kind of restrained or more deferential to Parliament. And again, there are some exceptions, but that kind of gives people a little bit of the lay of the land.
So the members of the bench are recycled for every administration. That's it, right? In Canada, in the parliamentary system, is it?
Well, not necessarily, because like I said, because they sit until age 75, often what happens is that you have, so for instance, on the Supreme Court of Canada right now, the majority of the judges are almost all still appointments that Stephen Harper had made. Now, there's a number of the judges that were appointed by Justin Trudeau, but typically a Supreme Court judge gets appointed, like say, either in their like late 50s or early 60s. And so it could be that a Supreme Court judge will sit for, 10, 15 years or so, and that might outlive the life of that prime minister that appointed them. So if they're appointed at a relatively young age, it's possible that a judge can sit, on the Supreme Court for quite a long time. So it doesn't reset with each prime minister.
That's a very good lesson there, actually, without going to school to learn that for free.
Yeah.
I have one final question about the structure.
Mm-hmm.
Why does it look like it's not distributed across provinces evenly? I didn't even know that, honestly.
Yeah. One of the things to understand about how Canada works is that kind of regionalism and the role of the province of Quebec and trying to balance different regional and provincial kind of interests and grievances in some case is what explains a lot of why our political institutions look and operate the way that they do. And when I explain this to my students, they're often like frustrated that why things are the way they are is because of these sort of like historical kind of quirks or bellyaching from the province of Quebec about certain things. In the case of the Supreme Court, there is a kind of a reasonable legal explanation, which, and this is somewhat technical. Part of what makes Quebec different, and there's a number of things about Quebec that's different from the rest of Canada, but when Quebec was admitted as a province in Confederation, they use a slightly different legal system kind of domestically within the province of Quebec. The English-speaking provinces use the common law system. For the private law in Quebec, it still uses what's called the civil code, which is the more European, continental European system of law. And this goes back even before 1867 to kind of a compromise that was reached when British colonized. The French colonists are already here. And so when the Supreme Court of Canada was created, because you have kind of these two legal systems operating, like one within Ontario and the English-speaking provinces, and then you had this unique feature of Quebec's legal system, there was this decision made that there needs to be at least 3 of the 9 judges, or actually originally 6 justices, but now we're up to 9. 3 of the 9 need to come from Quebec by law, because if there's cases that come from the province of Quebec to reach the Supreme Court, you need to have justices on the court that had expertise in the civil law system. And so, but then that kind of starts this interesting kind of domino effect of, if Quebec is going to get 3, then Ontario is always going to get as much influence as Quebec is. So then Ontario gets 3. And then as other provinces were added on to Confederation, then additional seats started to be added to the Supreme Court itself. And so you have this sort of regional distribution, which is not really very equitable. But there's a number of things about the way that the Canadian political system works that actually is not very equitable in terms of whether it's, population versus the amount of kind of influence or seats that a region has. So the Canadian Senate also suffers from this problem that there's more representation in Ontario and Quebec and Atlantic Canada versus, say, the West, that they get far few senators than their population ought to reflect if we did things actually in a proportional way. And so a little bit about the structure and why it doesn't quite line up, not one justice for each province or anything like that.
All right, let's transition now. I think that I actually learned just listening to you about that. Many things I didn't know in the past. I think this is where I have a knowledge gap because one, I didn't grow up in Canada, but yeah, that's really helpful. So I drew a line here. On one side, I wrote the political constitutionalism. On the other side, I wrote the legal constitutionalism. The US is representative of the political constitutionalism, and Canada, UK, Australia.
So the book that I wrote uses this distinction to think about the relationship between how much power the court has within these different systems. So again, to oversimplify a little bit, those former British colonies plus the UK, so the UK, Canada, and New Zealand, those states still allow kind of more of the final say for the parliament and for kind of the political branches of government over the courts. And whereas in the United States, it is a system that is most symbolic of a system based on judicial supremacy and this other view called legal constitutionalism that the book uses. And so the part of the book kind of keeps going back to thinking about this as being kind of like a continuum, and that you can kind of align these countries along this continuum, with the US being kind of on one extreme and then kind of plotting the other countries at other points of the continuum, if that makes sense.
So the points in the continuum now, if I understand you right, will be the US on one extreme in the judicial supremacy, and you're going to have New Zealand, and then you're going to have the UK, and then you're going to have Canada. Did I say that right?
The US being like the most legal, and then I would put Canada next, and then the UK, and then New Zealand. And so part of what's ironic is that this system of Parliament having the final say, is founded in Great Britain, but it's one of its colonies, New Zealand, where it's still operating in the kind of purist British style system. And it's kind of funny that even the kind of mother country of Great Britain, it too has sort of slid more towards the US style of doing things. And so anyway, and that's one of the conclusions the book comes to, is to think about how this process that's played out amongst the different states and where they've kind of found themselves.
Right. So in that regard, that means in an idealistic world, that means the US and these three countries, Canada, UK, New Zealand, should have been binary, but now it's a continuum.
Yeah, that's
three
right.
countries, three ancestry. How did the three countries diverge?
So in terms of like all these countries adopted charters of rights for things that look like our Canadian charter within reasonably close succession of one another. So after World War II, because of the atrocities associated with World War II, there was this new emphasis and consciousness about rights, and that we need to take human rights more seriously. And there's a Universal Declaration of Human Rights that the UN passes. And throughout the democratic world, more countries start to think more systematically about how should we go about doing this. And so Canada gets its charter in 1982. And the Canadian charter, I mean, it makes Canada more like the US in some ways, which is ironic because the charter is like a great Canadian symbol and a thing that Canadians kind of, the charter and its values are kind of emblematic of Canada's values. But by adding a codified charter that judges interpret, it's made Canada operate in practice more like the US system does in terms of judges having more influence over these rights issues. But Canada included in its charter this thing called the Notwithstanding Clause, which allows for Parliament to still have the final say over at least certain rights issues. And then when New Zealand and the UK were debating doing something similar to Canada, like maybe we should have one of these codified rights documents too, they, looking at the Canadian experience, actually kind of saw Canada as a bit of a negative case study insofar as you already, even in the early years of Canada adopting the charter, the courts having more and more of an influence and a final say over matters. And so the New Zealanders and the UK actually included a number of mechanisms to try to still give the Parliament the upper hand over the courts. But part of what's happened in the intervening years is that the judges in those systems have found kind of creative ways through interpreting the rights document to kind of stretch its meaning to cover more and more things that the drafters would not have intended. So this process has played out in different levels of degree, depending on which country we're talking about. But in terms of kind of the big picture that I'm trying to describe in the book, is that there does seem to be a momentum of once one of these parliamentary states adopted one of these rights documents, it starts to operate more like the courts in the US system does. And that's interesting to me. And so one of the things that we do in the discipline of political science is try to understand not just kind of what's happening in an individual country, but to try to draw kind of insights from political phenomenon that are happening across various countries, that various countries start to wind up in the same place. And again, there are kind of local or kind of national differences that are still important. And there's complicated explanations for why some of this plays out a little differently from one state to another. But I think the kind of trend lines are fairly.
So would you say that we're seeing a quiet transfer of power from ballot boxes to the bench?
Yes. Yeah. I think that is what's happening. So there's kind of a couple ways to look at this. There's sort of just sort of empirically, like, is this happening? Like, are courts deciding more and more of these controversial issues? And if you pay attention to the news in countries like Canada, you will find, like, every few weeks there are headlines about courts, whether it's like a lower court or often the Supreme Court of Canada is making a decision over, sometimes something that is, like, on its face very controversial. So we had a decision a week or so ago about mandatory minimum sentences for individuals possessing child pornography. So obviously child pornography is a very controversial issue. Or then also, like, really kind of peculiar and kind of wonky things like a judge in the city of Toronto saying that Premier Doug Ford could not remove bike lanes from the city of Toronto because that violates rights in the charter. And so you get these headlines that are weird about, there's nothing in the Canadian Charter of Rights and Freedoms about bike lanes, but here you have a judge through these sort of creative interpretations reading the rights in the Constitution in a particular way to spit out a decision that prevents a government from doing something that, again, we think is sort of like part and parcel of, we can have a separate debate about the merits of bike lanes. We would think that, like, that's something that the legislature and the Ontario government ought to have discretion over, but more and more issues keep getting, as I say, kind of like legalized or constitutionalized and decided by courts rather than parliaments.
Right. I think that's such a very, very interesting. You mentioned in passing too, just earlier, you talked about other polarizing issues. You feel like you're walking on eggshells, or you start to self censor already. You mentioned in passing, I noted here the Supreme Court's decision on assisted dying. That kind of issue, should it have been actually decided by the court or by elected officials?
So this is a matter that actually was decided in the past by Parliament. And again, there's sort of a long kind of legal saga here. Part of, I think, what would be kind of interesting to your audience to think about is that back in 1995, someone challenged Canada's law banning or prohibiting physician-assisted dying. And this was decided by the Supreme Court, and it was a very divided decision by the Supreme Court. So 5-4. And when you have a 5-4 decision by the Supreme Court, that kind of speaks to how hard the issue is, that, these are 9 very educated, kind of eminent people, and they have a very tricky time coming to a kind of clear decision on the issue. But in that 1995 decision, that Parliament has the ability to prohibit this. And we are commenting on, like, whether Parliament ought to ban this, but it's clearly within the powers of Parliament through the criminal law power that it has to ban physician-assisted dying. And then in 2015, the exact same issue, physician-assisted dying, comes up again in a decision called Carter, and the Supreme Court reverses itself and says, actually, we were wrong in 1995, and this is now unconstitutional. And banning physician-assisted dying is inconsistent with the Charter, and the court has kind of creative ways of it's very reluctant to admit that it's overturning one of its own precedents. What it will say is, well, the kind of values and of the society have changed in these intervening years, and these other countries are doing this now too. And so they'll bring to bear polling or social science data to back up their decisions. But that's an issue. And there's lots of other ones that one could point to where it used to be decided by Parliament and now it's being decided by courts. And in some cases, you have decisions where the courts have said, this is not something that we can weigh in on. And then they end up changing their mind because the composition of the bench changes, or maybe they feel like now the public is ready for them to weigh in on that issue. And so again, there are lots of examples that one could point to. So the physician is a dying one is one of them, but there's lots of other ones too.
Pretty much, it was like the Supreme Court decided on this case, and they handed it over to Parliament to pass that, and then it became a law. Canada on the side of the judicial supremacy leaning towards the US angle. But now if we take the middle ground, let's look at a country like the United Kingdom and Brexit, for instance. I think Brexit might actually be an example of a case where courts didn't have the absolute powers in making decisions. What do you say?
So yeah, that's right. So with Brexit, you have it decided by a national referendum. And so that's kind of, the ballot box still playing a important role. But then, the details of this case are going to elude me right now, but there was actually a court case about kind of related to Brexit and the ability of a prime minister. This is when Boris Johnson was the prime. He wanted to prorogue the parliament, and it was related to the Brexit process. And for the first time, the UK Supreme Court actually kind of curtailed or weighed in on some of these powers of the prime minister that were thought to be kind of prerogative powers that kind of weren't normally something that would be judicially supervised, something that judges could weigh in on. And they took this opportunity to do that. So you're right that kind of the referendum process, it wasn't decided by courts. But there are these sort of kind of footnotes to that process where the courts, I think, were kind of putting their thumb on the scale a little bit and had a particular view and weren't very sympathetic to the Brexit case. But
yeah, would there be any other case that you would mention for the case of New Zealand to actually drive home that point that they are on the other extreme?
So the New Zealanders still have, there still tends to be more of a kind of reverence for the parliamentary process. And so New Zealand has a very pure kind of British system almost. So there's no federalism in New Zealand. So there's no subnational governments. So there's no provincial governments or state governments. There's just a national parliament for the whole country. And there's also no upper house in their parliament. Like there's no Senate or House of Lords. And so it is a kind of a pure parliamentary system. And they had a period in the 1980s where they had some fairly really strong kind of almost dictatorial prime ministers really throwing their weight around. And that kicked off some reforms to try to rein in how much power the executive and their prime ministers would have. And so the New Zealanders adopted a form of an electoral system based on proportional representation. So you have more coalition governments in the New Zealand system. And then they added the New Zealand Bill of Rights Act, which is kind of their equivalent of the Charter. But the New Zealand Bill of Rights Act is the most kind of mild form of rights document that any of these kind of case countries that I talk about has adopted. The parliament there really does have the final say still over most issues. The most that their judges can do is they can say, this law that parliament has passed is inconsistent with rights that are enumerated in the New Zealand Bill of Rights Act, but the courts don't actually have the ability to invalidate or strike down the law. So all that the court decision does is kind of flag for the government, like you might want to look at this again, but it doesn't actually veto the law. Whereas in Canada and the United States, if the court says this law is inconsistent with the rights document, because of X and Y and Z, then the law is of no force or effect. That's the kind of legalese that's used, which means that the law is extinguished. It doesn't exist anymore. And so that gives courts a lot of power to effectively veto the laws of the elected legislature. So I imagine the judges in New Zealand, they pine to have the kind of power that the judges in the Canadian and American system do, because again, based on my reading of what's happening in these countries, like if you give judges like a shiny toy, like a Charter of Rights or a Bill of Rights, like they're going to use it because they can. And I think that's kind of like self-interest or human nature or something like that.
Can I turn your attention to the numbers on the screen for a second here? Because it shows over 90% of the regular viewers on this channel haven't subscribed yet. It goes a long way in helping us improve the quality of work, the conversation, and the guests that you see on this channel every time. If you could just click the subscribe button right now, that would be very helpful to bring that number down to about 80%. Well, thank you very much. Let's get back into the conversation. So let's come back to Canada. We've looked at this through a global lens now, there's 3 countries, but let's fall back on Canada for a second. When you look at issues, I just noted here as we're talking, issues related to trans rights, we almost decided that is almost the same way the US made that decision. Not to go into the details of trans rights now, but just the legal side of this. And if you look at issues about vaccine mandates just a few years ago in 2020, 2021, or even Freedom Convoy around the same time, are those examples you will say of judicializing everything, going by your title there?
Well, so in those cases, and again, this is sort of interesting that I find that, if we go back to like the COVID years, I found the courts gave actually a lot of latitude to governments, that there was a kind of consensus that, I think that a lot of the things that governments were requiring people to do, you could kind of see on their face that they would be inconsistent with the protections, like the rights enumerated in the Charter. But in that moment, that governments were given a lot of latitude to legislate things, and this sense that this was an emergency and therefore we're going to give the government a lot of room to maneuver. Because if you think about a number of the things that people were being asked to do, so people couldn't attend, places of worship or places of worship in person, that would violate freedom of religion. You had people being barred from moving from one province to another. You had like maritime provinces having really harsh restrictions around like not being able to move into the Maritimes instance. You had the judiciary in Canada, and the way that they had interpreted some of these charter rights in the past led them to, just to give the governments a lot of room to maneuver. And so part of the way that courts in Canada interpret the charter is through the first section, talks about that our charter rights are guaranteed, but they're subject to quote unquote reasonable limits. And so the government needs to justify why it's necessary in this case to infringe upon a right. Because of, if we're just talking about COVID specifically, you can think about part of the way in which that issue is framed is like you exercising your liberty or freedom is going to have these perverse, effects on others, or will be these externalities that you're placing on other people if you don't adhere to these guidelines. And so there was a number of issues of litigation, of charter challenges that were took into court about COVID restrictions.
So it sounds to me like it's not a question of how these policies or these laws are enacted. It's actually about what. And by that, I mean, I think you alluded to that also in your book. It's stretching even into private citizen dispute. Actually, I think you opened up your book with the Jehovah's Witness case, which I actually looked it up. It was a very interesting case.
Yeah.
But am I right with that assumption that it's not a matter of how, it's more of what these judges are getting into? Is that right?
Yeah, that's right. So kind of a lot of our discussion so far, we've kind of focused on, courts making these decisions and what it means for kind of like democracy or parliament, and kind of, you can think of, kind of like how much bandwidth the elected officials have to kind of maneuver after these court decisions. And that's kind of one aspect that the book focuses on. And then the other aspect that I focus on in that book and some of my work is how these standards of the charter and charter rights start to stretch and creep into other areas of the law that aren't actually based on kind of government action, or at least direct government action. And what ends up happening in this kind of strange way is the kind of application or the kind of reach of the charter starts to stretch into not just things that government do, but also in context related to, kind of like the private sphere or private life. And so, yeah, so the book opens with this Supreme Court of Canada case, but it's kind of an anecdote for other things that the book talks about, which is so this case concerned a Jehovah's Witnesses church in the city of Calgary. And so there was a member of this church. He had essentially been kicked out of his church. So to be a member of the church community, there was kind of a code of conduct that one needed to adhere to. And in this fellow's personal life, he had an issue with alcohol and had a falling out with his spouse. So his parish had its own kind of judicial proceeding, and he was what's called disfellowshipped, which is kind of like the formal term for being like excised or kicked out of your church community. Like, you can still be a Jehovah's Witness, but you can't keep coming to our place of worship. You have to find another church to join. And so he challenged judicial decision that his church came to, that the way that his congregation had come to this decision was inconsistent with principles of natural law and administrative law. And this decision went all the way to the Supreme Court of Canada. And ultimately, the Supreme Court sided with the church and against this fellow who challenged the decision. And the court said, the charter is about restricting government activity. It's supposed to apply to things that the state does. It's not supposed to apply to private activity. And that's mostly true. But my book also talks about how there are a number of these kind of edge cases of where this isn't necessarily something that the judges have done on their own, but there are cases where litigants, so people challenging different laws, will try to turn their private dispute and bring a constitutional or charter angle to it because they think that will be a kind of winning argument. And sometimes the judges involved in these cases are persuaded by that because the judges have kind of an institutional self-interest to expand the reach of the charter into more and more things because it gives them more discretion and more scope to decide things. And so there's kind of this sort of perverse, I think, relationship between, or kind of ratcheting effect of, that the charter has come to apply to more and more disputes. And so again, that's kind of what the title of the book, Judicializing Everything, is kind of alluding to, is this is about government, but it's actually about other things beyond just things that governments do.
I'm weirdly thinking, are there cases actually that the courts actually lost and the people's wish prevailed?
Yes. I mean, there are, I guess I've been kind of focusing on kind of like the role of the courts, or the courts being kind of the ones that are driving all of this. But I guess maybe one thing that we haven't talked about as much that I should raise is that the politicians, the elected officials, they've kind of allowed or facilitated some of this to happen because I think it makes their lives easier. So, courts don't create bills of rights, or didn't create the charter. This was done through a public process, and there were lots of votes and debates about adding all of this. And if you're a politician, some of these controversial issues that we've been talked about, they're squeamish to talk about, particularly if you're an elected official, because you have to pick a side, and picking a side is going to, cost you votes, maybe, from one half of that issue. So courts have been taking on more of these issues, but our elected officials, a number of them, have been really keen to kind of outsource or subcontract out these divisive issues to the courts, because the politicians can kind of just say, well, like, the judges made us do this. I don't like the decision that the court has come to, but like, what are we going to do? It's what the Constitution requires. And there's even instances where not only does this has kind of been used strategically, of if there's a particularly controversial issue, that a prime minister or a premier of a province can say, well, we're actually going to ask the courts to weigh in on this, and let's let them tell us what they think, what the Constitution requires. And that allows the politician or the leader of a party or a prime minister to kind of quell internal dissent, maybe from his own members who feel strongly one way. And so you're kind of, well, let's just sort of, instead of us debating this and, being at each other's throats, we'll just allow this other institution to weigh in on it. Let's see what they have to say. And that's a way of sort of kind of depoliticizing the issue. But that doesn't mean that the issue is still not, important, or it's not still kind of political. It just means that you're kind of asking another institution to do it for you. And so the elected officials have been, in many cases, kind of complicit in facilitating this process.
it's a better alternative to just use the ramp to get to the same destination by elected officials, if the loophole is there, right?
There's a lot of different things going on with this. And I often, I talk to my students about some of these issues about that, some of these controversial issues, if you only kind of read them like kind of on the headline of like a news story or something, they often seem more straightforward than they actually are. And, politicians, elected officials are very responsive to, the media or kind of short-term decision making and are very, want to avoid, negative stories about like what they're doing and these sorts of things. And so responding to a court decision that is about a controversial issue, unless it's something that's quite germane, like core to that party's, like what they got elected on, it's easier to just be like, to kind of shrug and to be like, look, the courts have weighed in on this. Now, if it goes at something that is diametrically opposed to what like that party was elected on or something like that, then there's going to be more of an appetite to push back against the things that the court has said. So there are instances where there is pushback from the elected officials. And but again, I would say kind of at a kind of broad level that in a lot of these issues, like I said, Canadians or public opinion tends to be fairly deferential to courts. And part of it is that the language of rights is very difficult to argue against because like everyone is in favor of rights, right? Like, well, you need to be like really on the fringe to be like, I'm against, freedom of expression or against, equality or against et cetera, et cetera. So these issues end up getting presented sometimes in a kind of black and white issue of, the court says there's a right to X. So anyone who disagrees with that is now like denying people's right to something. And that puts you kind of on the back foot. It's very difficult to argue the opposite side because the more nuanced position was not that I deny the right, it's that I think the court came to the wrong interpretation about like how that right ought to be exercised in that case. And there's another way of crafting a law or a statute to get at that issue. And what I just did there in that example, like there's kind of an adage in politics of if you're explaining, you're losing. So the more nuanced position is more difficult to kind of unpack to the audience sometimes, not an audience that listens to a show like this, of course. But if you're just talking about like, kind of sound bites or what's in the media, a headline can look like, Prime Minister denies rights of this group or something like that. You don't want to have to like wear that. And so if you can say, the courts have made their decision and I'm going to respect that because that's what a good democratically elected person does in Canada, then that's a far easier position to hold.
I want you to give an example of that. I think we should start finding our way home here, but I want you to give an example of that, actually, what you just described.
Let me see. So I guess like a good example of politicians doing what I just described was how Canada came to adopt same-sex marriage. So this was back in 2005 that Canada broadened the definition of marriage from the traditional definition of a man and a woman to the exclusion of all others. That was the original legal definition. And then in 2005, Canada passed a law defining marriage as, a union between two individuals. So no longer having any kind of designation in the definition of marriage. And so at the time, this is now 20 years ago, the same-sex marriage issue was actually quite divisive in Canada. And not even just divisive in the sense of like liberals versus conservatives. So we had a liberal government at the time. And the issue was actually quite divisive, like within the Liberal Party itself. Again, some of this is like kind of ancient history, but in Canada, Catholics tend to vote Liberal more often, not always, but there's a strong relationship between Catholic voters and the Liberal Party. And there's lots of social science research to back that up. And so the Liberal government at the time, this issue was very divisive within the Liberal caucus itself. And you had a lot of people within the Liberal Party wanting to retain the traditional definition of marriage. And you had people in the Conservative Party who also felt that way as well. But then you also had people within the same party, within the Liberal Party, who thought that Canada should broaden the definition of marriage to include same-sex couples. And so Canada's constitution has this mechanism called the reference power. And so a prime minister can ask the Supreme Court of Canada a hypothetical question about a legal question. and the court can weigh in on that hypothetical. And so the government of the day asked the court, would it be consistent with the charter to extend the definition of marriage to same-sex couples? And so there were 4 specific questions that were asked in this legal process, but the Supreme Court of Canada issued its opinion in this case, and the court was actually very kind of coy in its answer and said, adding the definition of marriage to include same-sex couples isn't required by the Constitution, but it wouldn't be unconstitutional. So the court didn't actually come out and say the charter requires this, but the way in which the government chose to interpret the court's opinion was to present it as if it had to do this, and as if to say, we've asked the court what it thinks about this issue, and the court has said that the same-sex definition of marriage would be consistent with the charter. And so, the Liberal Party is going to put forward a bill in the Parliament of Canada to make that change. And so that's an example of how, if you didn't have a charter and the courts had no final say, you could have just had a parliamentary process to hash that out. But it was convenient for the government of the day and for the Liberal Party to have this other institution that it could kind of lean on and kind of subcontract out the difficult question to, and make the question seem like it was a technical legal issue, rather than just one that was part of politics. And so, so that issue is not controversial anymore because the definition has been changed for these past 20 years. But at the time, this was like front page news. It was covered for a long time. And it was a very big deal.
Interesting. That sounds like the court has become a wild card, So you can just pull it off and use it to win the game when it's convenient. Let me add to that. Your critics would say it's either the courts have the power to make decisions or not. And why the hell in the first place do we have them if they can't make decisions? The people on the other side who are beneficiaries of that will use it as a wild card. How would you respond to that?
I think that the courts and the Supreme Court especially, like I said, the powers that it has, some of it, not all of it, but some of it is the product of, a democratic and political process. There's a Supreme Court justice who's now deceased, named Bertha Wilson. She was the first woman ever appointed to the Supreme Court of Canada. And she wrote an article once called "We Didn't Volunteer." And the title being as in, the democracy chose to add a charter and now we're just doing our job as required under the Constitution. So we didn't choose this. We didn't volunteer to become the institution with the final say. And so I appreciate that and take that point. But there are lots of other things that the court has done where it has been more kind of adventurous or creative and has really stretched the meaning of the text of the Constitution in ways that I think would make the people who drafted the charter would be very surprised in kind of where we've ended up. It's, and I don't think that the role of the courts is going to change anytime soon necessarily. And I imagine that the court is going to keep making lots of headlines for lots of time going forward too.
I find sense now when some of my lawyer friends, which is interesting, I remember now that many of them will say part of the problems that they have in dealing with the Canadian law generally is the question of rights. And they will say among the G7, it looks like Canada has the most rights and it's so open-ended that you don't even know where to turn sometimes. I think it gives me a clue to what they're saying, because essentially you are going to the back end of these problems. And let me say it like this in another way. It's like when I read the comments on my videos online, people will quickly say, which I would expect some of those kind of comments right now from this conversation. People will quickly say, well, Pierre Poilievre does the same thing, as though, this is a critique of the Liberals, as it were. I actually try as much as possible to avoid the conversations about blue versus right. Yes, I have my own political leanings and preferences, but I don't let it really overshadow conversations here. What I'm looking for is why and what is left that can be saved. Why do we do what we do? Why do people even believe the things they believe in? Which I think it's the back end, the philosophical angle to many things that we see that people can actually talk about. Generally in a Tim Hortons cafe or something. But here, what I really want to get into is the philosophical angle, the background, the backbone of conversations. And this is what we're talking about. Institutions and rights are actually very intertwined. And they determine a lot in whether institutions are going to be strong or weak. And what I'm hearing you say, honestly, Mark, is our institutions are either going to suffer or become strengthened because of these topics that you're raising about judicializing everything. Critics can say whatever they want to say, but I think that's what you're trying to say. I'll let you chime in on that, and we'll just do one more questions, and we'll find our way home.
I think that part of what has happened in Canada is kind of a combination of things. We had this British tradition where courts weren't that important, meant that courts were thought to be fairly kind of neutral. And they were kind of like umpires that they would adjudicate disputes. And so kind of built into that was a strong kind of reverence and deference to courts. And then by adding the charter, and like I said earlier, this kind of Americanization of having courts having the final say, that the kind of combination of Canadians being fairly deferential to political institutions, that they come to the right decisions most of the time, and so on, that has given the courts a lot of leeway, and that they have chosen to kind of throw their weight around, for lack of a better term, and exercise that authority that they have. And so in some ways it kind of is reflective that, Canada's democracy is I think like fairly strong, or we have fairly robust institutions. And some of what I'm kind of criticizing or raising are, some of these are, again, kind of sound like, maybe kind of good problems to have, depending on if you don't have, a very strong human rights record. You mentioned kind of developing states and those sorts of things. But again, I do think that kind of getting back to your point about kind of like philosophically what's going on is that this is one small part of a process of more and more decision-making slowly moving from kind of regular people to elites to another group of elites, in this case, kind of judges and lawyers in court.
But I think we can solve a lot of the problems that divide us as Canadians if we solve this problem you're addressing here. Because go on the street, what divides us is topics about the definition of family, of marriage. What divides us, it's topics about Freedom Convoy. That still divides Canadian more than anything right now. It's topics about MAID and different other topics like that. Those are the things that divide us. So I think if we can solve this problem you're addressing here with judicializing everything, we might actually become a little less, at least, divided as a people.
Yeah, this is maybe maybe just to kind of to end on kind of an optimistic note. What I would want is if more of these issues could be returned to the kind of democratic or political realm, for them to be subject to reasonable disagreement and decided, through the ballot box and within democratically elected legislatures. I think that would lead more legitimacy to the decisions. I think that part of the problem with courts deciding these things is that it kind of cuts out regular people from being able to have a say or debate the issue. It's kind of presented as this has been decided and now we need to go along with what the new output of that policy decision is, rather than it being kind of subject to democratic disagreement, and we can undo it and redo it or tinker with the decision. That once it becomes judicialized and constitutionalized, then the output is way more difficult to amend or change. And so that's kind of the stakes of this. And so if we can get back to like less judicialization, then I think we would be in a better position.
Right. So let's wrap up like this. We've actually started from talking about the courts, the structure of the court, which we identified that many Canadians don't know. A lot of things you taught me there actually on the spot. I didn't know some of them in the past. So we talked about that. We talked about different jurisdictions. We took, for example, compared on one extreme the United States, and then the continuum all the way to New Zealand, Canada, and the UK in between. And then we talked about why those three democratic nations actually ended up on a spectrum. And then we've actually talked about Canada to greater details and the role of the court and why a lot of nuanced topics in the Canadian system is actually being sent to the court, and how politicians are using the court as a wild card. And you've actually talked about the note of optimism there on what could be done. Let some of these things return to the actual democratic process in the hands of elected officials. But finally, how would you want an average Canadian to interpret this? What can they do better? And I know this is always challenging when it comes to talking about technical topics like this.
Being involved and paying attention to politics, like, voting and taking the democratic process seriously and letting your elected representative know that you pay attention and care to the decisions that they make is part of it. And so I think that, and being kind of open to thinking about that, just because a court has made a decision doesn't mean that needs to be, that's kind of the same as being kind of normatively correct or something like that. So that there's still, it's permissible to disagree with decisions that courts and the Supreme Court of Canada make, that the judges are not, some kind of gods or guardians of democracy or these sorts of things. They're very qualified and eminent legal minds, but a lot of these issues that they're deciding are just, like I said, are kind of controversial, but they're often kind of philosophical or normative issues that lots of regular people should have the ability to weigh in on. So I would say, be engaged and pay attention to what courts and what our politicians are doing, and some of that might go a bit of a long way to improving things.
Right. Yeah. Right. And choose your leaders right. I always tell Canadians that you won't get anything better than the quality of leaders you choose. But thanks, Mark. This was a great conversation. I learned a lot actually listening to you. And I think that for me, that's an accomplishment for this podcast. I don't know how you feel.
No, it was great. I was glad to be here, and it was a great conversation.